ensayas rápido, no te sabes poner pie. Lo ensayas rápido, no te sabes poner pie.
Welcome again to another episode of Civil Discourse Now. I'm Mark Small, and I am the only host today. Usually Paul Ogden and I co-host, but this is kind of a special edition of Civil Discourse Now. Paul, do you want to explain what the nature of the show is? Usually Paul says that.
The nature of the show is a civil discussion of local, state, national, and international issues. Mark decided, and I think he's quite right, that there are too many shows out there where people are yelling at each other and talking over each other. And Mark wanted to have a show that brought a civil discussion to the issues.
And try to get more of an intelligent discussion of various issues. Today the issue is going to be the methods by which we select judges. Now, our guests, and this is why Paul is not a co-host today. This is kind of the special nature of the show. Our special focus is going to be on the race for Marion County Superior Court judge in the primaries. And the reason he's not a co-host so much today, and I am kind of a moderator, is because he is a candidate for Marion Superior Court judge. Our other two guests are Mark King, who's also a candidate for Marion Superior Court judge for the Democratic Party in the primary, and Greg Bose, who's also, all three are candidates for Marion Superior Court judge. They're running in the primary, and Mark and Greg are running in the Democratic Party, and Paul is running in the Republican Party. And if you gentlemen would each...
Let's explain the fact, Marion County system, 20 people will be elected in the general election. You have Democrats put up 10 people, nominate 10 people, Republicans nominate 10 people, 12 are running on each side. Now, typically, whoever the Republican candidates are who get nominated and Democratic candidates who get nominated are going to be elected in the general election. There could theoretically be a third party come in and beat one of them out, but it's usually unlikely.
Let me try to simplify that. There are 36 judges' positions in the Superior Court in Marion County. The two parties, through the General Assembly, split those seats down the middle so that the Democratic Party has half and the Republican Party has half. Technically, they don't. Technically, you could have a write-in candidate for the general election and they could run outside. Otherwise, each party has half. That means those candidates who win the primary for their parties, and correct me if I'm wrong on this, gentlemen, but that means those candidates are pretty much assured of a victory in the general election. And that's under Indiana Code 33-33-49-13. And it describes how, it doesn't say we're going to split this between the two parties, but it says they'll be evenly divided. A political party may nominate not more than 8 candidates for judge of the court. That was in 2006, and then that goes up to 10 for the next general election. It says a political party. It doesn't say the Democrats or Republicans, but the way in which the statutes are set up, that's the way it actually functions. So these gentlemen are running as candidates for judge in the primaries, and Mark, do you want to give an introduction to our viewers and describe the qualifications for office?
Thank you, Mark. Hi, I'm Mark King. I'm running as a Democratic candidate for judicial nomination. I have been an attorney for 13 years. I've been both a prosecutor and a public defender, and I sit as a pro tem judge on a regular basis.
Greg? Thanks, Mark. My name is Greg Bose. I'm also a Democratic candidate for Marion Superior Court judge. I've been a lawyer for 26 years. I've been in practice for most of that time. I've served over 500 clients. I've worked on both civil and criminal cases. I've done criminal defense for a short time. I was a deputy prosecutor. I've done trials. I've done appeals. I've done administrative cases. I've done bench trials and jury trials, and I've done all sorts of different kinds of cases. I also had the honor to serve on this Indianapolis-Marion County City County Council for 3 years and served as the Marion County Assessor for 4 years. And I'm hoping that brings enough depth and breadth of experience to be a good judge.
Paul?
Thanks, Mark. Well, I've been an attorney for 25 years, graduated in 1987. Served as the Deputy Attorney General doing jury trials and eminent domain cases, also did state personnel. We represented the Department of Highways, which is now the Department of Transportation, as well as the Department of Natural Resources. After that, I left, became a clerk at the Indiana Court of Appeals for Judge Buchanan. Worked there for 3 years under him. He retired in January 1993. I stayed on for 6 months under Judge Friedlander, who took his position. After that, I went into private practice. Was at a law firm in Carmel. Was at a law firm downtown, Robertson Bishop. Been there for 3 stints. During some of the time, I've also been the general counsel for a title insurance company, and I was also head of the title insurance division. When I was in college, I actually worked in the state legislature as well, interned for a couple of Republicans there. I've actually worked in all 3 branches of government, and as my friend Mr. Bose and Mark had a lot of experience litigating cases in Marion County, including civil and criminal cases.
And I had contact with Mark, and you were with the prosecutor's office with the grand jury division, and I remember having several meetings with you on a matter. I mean, the subject matter is irrelevant, but that was an interesting procedure because I'd never gone through grand jury procedures before. Of course, as a defense attorney, my involvement in that was limited, right. But I had interfaced with you, and that's an interesting area of the law in which to work.
Yeah, the grand jury is a very interesting concept because it allows citizens to decide charges against individuals. And it's sort of like a mini trial inside the grand jury where you present evidence and you try to indict somebody with a crime. It's very popular in the federal system, but it's not so popular in state law. In state law, usually a prosecutor sits behind the desk, reads a probable cause affidavit, and charges somebody with a crime. So I found it very interesting. While I was at the grand jury, I was also doing double duty as the gang prosecutor. So a lot of my focus was on criminal activity and violent gang activity inside the city, and specifically on the west side.
Each of these gentlemen is running. Okay, let me go back and describe what it is that we have in this country as a judicial system. Our judicial system originated with the colonies, and they had a hodgepodge of various court systems in the 13 colonies. When the Constitutional Convention was convened in 1787 in Philadelphia, there were general concepts of what the delegates felt should be in a judicial system. And there they were dealing with the federal system. What came about was a Supreme Court with life tenure judges and district courts with life tenure judges. And an intermediate court of appeals eventually sprang up that had life tenure judges. The debates at the Constitutional Convention were between appointment and election of the judges, and also between independence and accountability. And those are basically values that we see today that are at issue when we're talking about judges being in office. Judges are different from other people in political office because they're not supposed to advocate. Judges listen, they decide, they're either fact finders in a trial or they're making decisions in review of some matter, but that goes into the nature of what a judge's job is, and we can talk about that in a bit. Alexander Hamilton believed in appointment of judges. He believed lifetime tenure meant that they'd have the independence that they need. Thomas Jefferson thought that he could fire all the federal judges if he wanted to once he took office. A very important case was the impeachment of Samuel Chase, first Supreme Court justice to be impeached. The impeachment trial was unsuccessful. He was found not guilty. That has continued as a debate because over time, when people see or hear of controversial cases being decided by a court, they question whether they can remove a judge or a panel from office. That's why the Supreme Court decision in Brown versus Board of Education, for example, I don't think would have been handed down or even considered were it not for the fact that the Supreme Court enjoys lifetime tenure. That brings us to the end of this segment, and we'll be back in just a minute. Thank you.